So this panel discussion essentially is with regard to the theme. And we have listened to a very brilliant and interesting paper from the keynote speaker. The legal profession in a time of socio-economic uncertainty. We completely understand that for some reason, of course, which lawyers might find a bit difficult to explain, the economy has gotten harder, tougher, and it would seem that the economy and the quality of life for Nigerians, and then, of course, by implication, lawyers, is shrinking. So this topic and this theme is extremely apt, as of course it would help us discuss and assess and share ideas on what ideas there are for exploring the opportunities that exist, within the legal industry and in law practice, especially in very difficult times. And we think that there are no better persons and no better panelists to discuss the theme and to have a conversation surrounding the issue. So very quickly, I am going to take thoughts from the panelists. First from Mr. Justice, the Honorable Justice Peter Afen, and I would like to yield the floor to him to share with us, my lord, sir, to share with us what your lordship thinks, what the thoughts are, and what was extracted from this extremely brilliant paper delivered by his lordship. My lord, sir. So your thoughts, we would like to know what your thoughts are, what your opinion is, and what perhaps we can learn from you regarding the theme, and what new ideas that you can share with us.
Thank you very much, Mr. Moderator. My Lord, the Honorable Justice Obande Festus Ogbunya, JSC, Commander of the Order of the Niger, my Lord, the Honorable, the Chief Judge of Bar Association State, and all the eminent judges and justices present, and my learned friends, distinguished ladies and gentlemen, please permit me to stand on the protocols established. I crave indulgence to say that I have had the privilege of a preview of the paper presented by my Lord, the Right Honorable Justice Ogbunya. And in keeping with the finest traditions of our common law heritage, which is steeped in judicial precedent, I cannot but concur with the views expressed and the conclusions reached by its lordship, which at any rate are forcefully binding on me under the inflexible doctrine of stare decisis. A word or two on the guest lecturer. The guest lecturer and I are privileged proteges of the legendary Dr. C.C. Nweze. May God bless his legal soul. And I was also privileged to sit on the bench of the Court of Appeal as a panelist alongside my Lord before his well-deserved preferment to the Supreme Court at the Lagos Division. And if you are a lawyer who regularly consults the law reports, you would have discovered that we do not simply say that appeals are dismissed. Rather, we impose the deserved penalty of dismissal, or we penalize the appeal with dismissal. We also do not say appeals just lack merit. We say they are bereft of merit or they are destitute of merit. And we also do not say that cases are statute barred. We would rather say that the case is caught in the intractable web of limitation law. If you know, you know. I'm just saying that to underscore the erudition of the eminent jurists who are privileged to have listened to this afternoon. That we are experiencing the worst economic crisis of a generation. It's been acknowledged by international tabloids, including the New York Times, The Economist, and all of that. And although our economy is not officially in a recession, the indicators that our economy has gone south are all too glaring for all to see. And unless something is done to turn the curve, we are in for more difficult times. I mean, when you talk about inflation at above 33%, you are talking about youth employment at over 50%. You are talking about 133 million of our compatriots being said to be multidimensionally poor, etc., etc. The statistics could not be grimmer. And so what role, if any, can the learned profession, the legal profession that is populated by learned gentlemen, play in this grim situation we have found ourselves? In different words, how does the legal profession navigate the undulating contours of the economic adversity that is confronting us? I recall a wartime case in England. It's Liver Siege and Anderson, and every student of constitutional law is probably aware of that, where Lord Atkin threw a critical flak at the majority in a scathing dissenting judgment. He described the majority as being more executive-minded than the executive, and then famously remarked, I would quote his lordship, he said, in England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. I will leave it there. Now, war times are undoubtedly times of economic adversity. And so I submit that the role of the lawyer, whether in times of economic adversity or in times of peace, remains unchanging. And that is to keep faith with the rule of law. But the challenge we face today is the challenge of fidelity to the law. Of course, you and I know the unholy stratagems we adopt every now and again with a view to gaining undue advantage. In fact, somebody has once remarked that in our courts is not justice but voodoo. The words are not my own. But if you are truthful to yourself, we would all agree that we may not be far wrong. So that role we are supposed to play, whether in this time of economic adversity or in times of economic prosperity, is to keep faith with the rule of law. So we should examine ourselves and ask ourselves the pertinent question. Are we keeping faith with the rule of law? Or are we blaming our failings on the economic adversity that has befallen us? And as the IBA once remarked, if we take care of the rule of law, the rule of law will eventually take care of us. And I think it was Lord Halifax who once remarked that if the laws would speak for themselves, they would complain of the lawyers in the first place. Just imagine you cite Section 135 of the Evidence Act, and the Evidence Act is saying, no, that is not how I am. That's what we have turned our laws into. In fact, sometimes you hear arguments or you even see decisions and you begin to wonder, is that truly what the law intended? So what we are suffering is not inadequacy of laws, but rather we are suffering those whose fidelity to the law is questionable. Now, I just want to quickly add that countries that have set a lot of premium by the rule of law almost invariably are doing better economically. That is to say that rich countries are rich, not because of resources. If it were mere resources, then we should be the richest country and the wealthiest and the most prosperous people on the earth. But where do we stand in the scheme of things, in spite of our humongous God-given wealth? So the fault is not in our stars, the fault is not in our laws, but in ourselves that we are underlings. Now, I would just make the point that as we are grappling with economic hardship and how lawyers and the legal profession will cope with it, what we must realize that a period of economic uncertainty such as we are in right now is one in which the instinct for survival and self-preservation is topmost in the agenda, of most people. So more often than not, the experience of a rich lawyer would be that clients are looking for alternatives to your services. If they can do without you, they would do it. That is why they get people, they just copy your precedent and quickly sign it and agree with themselves just to avoid paying you your fees. Now, there is a research paper, and where I'm going to is that whether in times of economic crisis or in times of prosperity, another thing that would make lawyers poor if we do not brace up for it is artificial intelligence. Now, in 2013, as far back as 2013, where a research paper at Oxford University gave a stark prediction that half of all the jobs that human beings engage in could be automated by 2030. That's just about 16 or so years from now. And that out of the 4 boxes into which all of human endeavor could be compartmented, artificial intelligence currently undertakes 3.5, leaving only 1/2, just that half, left for you. And so we must come to terms with the fact that the contemporary phenomena we are confronted with, such as information technology, commoditization, outsourcing, external investment, have far-reaching implications for legal practice in the 21st century, and lawyers must urgently reconsider the sustainability of their traditional role, even as concerns have been raised in some quarters that lawyers might fade from society, just as other craftsmen have faded from society in times past. There are downloadable apps today, like Do Not Pay, that render legal services free of charge. That is considerable inroad into your turf already. Now, judges are not also spared. In May 2017, an artificial intelligence algorithm developed by the Illinois Institute of Technology practically rendered High Court judges obsolete by correctly predicting 72% of High Court verdicts, whereas human judges could only predict 66%. That is the effect of predictive justice. And as people are now more and more strangulated by the crisis in our economy, they will be looking for those alternatives to you. So lawyers must urgently reconsider their traditional role to see how sustainable that can be in the scheme of things. Otherwise, you will just be calling yourself lawyer, and they would have been getting the services you render without you. So, that for me is something we must pay close attention to, even as we grapple with this economic adversity that has befallen us. Now, in closing, evolutionary biologists would tell you that it is not the strongest of species that survive. Rather, it is those species that are more adaptive to change that will survive. To apply that to us as members of the legal profession, I submit that it is not the strongest or the most brilliant of lawyers that will survive. Rather, it is those categories of lawyers who are more adaptive to change that would survive. The only constant thing in life is change. And that change is staring us in the face. And if we must play that role that we are primed to play in a developing economy such as ours, then we must prepare ourselves to adapt to the change that is already with us. I thank you for this opportunity.
My Lord, thank you very much for your Lordship's extremely incisive, very interesting thoughts. We would spend the next couple of minutes listening to the thoughts of the other judges, and then, of course, we would have a proper and elaborate conversation, on the theme. Your Lordship, just very quickly before, of course, I call on your brother by your right hand. Some very interesting things that your Lordship said. For instance, one is it's extremely important to keep faith with the rule of law. And whether it is tangible or visible to the eyes, and you've pointed out that countries that are succeeding and doing well, if you look at their index, you would realize that there are countries that have a very good rule of law applicability and all of that. So it's extremely important. One very special thought that I'd like to hold on to. It's extremely important to have fidelity to the law, like your Lordship mentioned. And your Lordship ended by saying that lawyers must urgently reconsider their traditional role, especially in these very difficult times. It brings to bear something I read recently, that most of the major, powerful Fortune 500 companies in the world today are doing something different from what they started. So, for instance, you have a BMW producing vehicles, probably started producing plastics. Or you have a Michelin producing tires, probably started producing steel. And then over time, it was important because of sustainability and because you want to be in tune with the market. Of course, for lawyers, we can't wake up and decide that we want to practice medicine. But within the ambits of the law and within the profession, we can continue to recreate ourselves and continue to reconsider how we can improve on the traditional roles that we're used to. So, Your Lordship, I think that was extremely profound. We're extremely grateful for your thoughts, and we'll come back to discuss it again. A round of applause, please. So, it would be good at this point to listen to the Honorable Justice Timipres Songi, what His Lordship's thoughts are on the theme, and perhaps some ideas that His Lordship can share with us surrounding the theme. Thank you, ma'am.
Yes, thank you very much. I'd like to stand on the existing and established protocols for want of time, because time is fast spent. My Lord Justice Festus Obande Ogbonya did a brilliant presentation. In fact, listening to him, I was telling myself that these are just the things that I thought the legal profession is facing in this socio-economic uncertainty. One of which is insecurity. You know, the country is no longer safe. So lawyers find it difficult traversing the length and breadth of Nigeria to earn an income. I would wish that the government would do something about it. They say it's all our problem. But then I truly think that we know where the problem lies. We also know where the solution lies. My second take is on the fidelity to the law as expressed by my brother George on the senior side, Honorable Justice Afen. You know, the truth of it is that a society can only run when it upholds the rule of law. And who should uphold the rule of law? I think the legal practitioners should. When we find lawyers come to court interpreting that which is not the law and sounding as though it is, and thinking that the judge is on the wrong path, not listening to him or agreeing to his position, then it creates a problem. The other problem, and it does cast an aspersion on that lawyer, it is a ploy to create the impression to society that you can, by your arguments, change the course of the law, when obviously you're on the wrong side. Now, if society doesn't find your argument appealing, and then you go on with that trend, people don't come to you for your services, that's an impact on your income for lawyers. And then for the society at large, people see lawyers as the people who propel the rule of law, and if we don't uphold it, we're going to create a situation where we will find people not showing respect, and then we find the same lawyers justifying or defending that position. Now we are in this, the era of social media, so we have a lot of social media justice. Everybody is now a lawyer on social media. So when we find lawyers put out a position that is not the law, there is a problem, because you educate the uneducated public about law, but you do it in the wrong sense. Then you dwindle your income by so doing and expect the public to have confidence in you. So we have to build integrity as lawyers, because as the guest speaker rightly stated, it is until you stand firm as a lawyer that has integrity, whether you stand rightly or wrongly, you find that people love the truth. They tend to come towards you so that you can, you know, they believe that what you tell them, if this is your case I'm handling, I don't think you should, because this is this, that you may not succeed, than allowing a lawyer deceive you because of your money that is expected to make from you. And then at the end of the day, you lose the case. And you find such lawyers still egging the client on to say, no, we can go to the Court of Appeal. They will find differently from us. And you just wasting your money, and then you move on to the Supreme Court and the throwaway. And these days, the Supreme Court, they are not sympathizing. They slam costs on the lawyers personally. So it's a problem if you don't stand on truth. You need to stand on that altar of truth so that the legal profession can be seen as it was in those days. You know, I remember way back during the military era, you find lawyers daring the military, and you see them soft pedal because it was based on truth. So if we as lawyers can't stand for truth, it's definitely going to impact the economy. This is the era of social justice, whether we like it or not. And then we have the advent of AI, quite troubling. So it's taken away, even though it's a very good innovation that has come to stay, but it's taken away the job of young lawyers, young graduates. So you engage them initially for research work, you know, research, write small articles. Now you have law pavilion doing the job. So there is a problem. But then it brings me to the issue of continuous legal education, as highlighted by the keynote speaker, because the times are changing and that's the reality of it. We need to embrace technology and the world is moving at a fast pace, so we really need to embrace technology. But then my fears also with technology is, do we really have the capacity to combat the dangers associated with it? Now, if, for example, we automate our systems, our cases, how do we contend with cyber attacks? Because it's a reality. It's even happening in advanced countries where they even have the wherewithal to fight it. But example, I hear it happens. People attack university systems and change their results. It does happen. So are we also ready for that? While we copy what the Western civilized world is doing, which is good for me, I still hold some traditional views about our e-judiciary, e-this, e-that, because we do not have what it takes to forestall these attacks when it happens. So you don't have a judgment online that is different from what, and we see it happen, that is different from what people have as hard copies. Even the hard copies, you need to even look at it properly to be sure that it is what you read out that was actually signed and given out as certified true copies. So as we navigate this journey into this socio-economic uncertainty, and Nigeria we're in dire straits, frankly, we have found lawyers engaging in sharp practice. It all boils down to integrity too. At the times I had, but there's no justification for it. And I think that the MBA should do more to sanction lawyers who engage in those practices. Every once in a while, we find the NJC doing its own house cleaning, but we don't find that regularly with the MBA. So it's condoning what you see. It starts out with the juniors who work with you. You encourage them by not dressing properly. So they see the ones who don't dress properly as charge and bill lawyers. That's a bad appellation for a lawyer. I also find my very few years on the bench, I find lawyers who instigate crisis. Yes, they instigate particularly communal crisis. That's not very good for the legal profession, which in turn means that you contribute to the social injustice in society. You instigate crisis where they tend to settle. You tell them it's impossible until you approach the courts for them to settle. Even when the courts give judgment, you still instigate by filing unnecessary applications, and then you expect people to have faith in you and return to the court. So they seek for alternative means of resolution of their disputes. And all of those would impact the legal profession, because a time is coming, people may likely not approach a lot of lawyers. So you will find yourself, as my Lord said, working in banks, doing odious jobs with their BL, LLB and BL. That's not what we pray for. You know, the legal profession is a beautiful one. Well-honored profession that people love to be a part of. But then we need to conduct ourselves properly to gain the respect that we deserve from society. And when we do that, we'll be able to move forward with our society, because if we uphold the rule of law, we're actually referred to as gatekeepers in society. If we uphold the rule of law, we stand firm. Everybody would listen to you, but when you speak from both sides of the mouth, then there's a problem. So my take would be that we do our house cleaning, stand firm on the fidelity of the law, and then see how it goes. Advise people in authority correctly, where you serve in such positions, because it's all of that that has built the trust in societies we try to emulate so that the legal profession can stand the test of time, in spite of the changes that are coming to society and the world at large. Thank you very much.
Thank you very much, my Lord, for your very special and erudite thoughts on the theme. There are a few takeaways for me as moderator and perhaps for every one of us lawyers who are here, lawyers and judges who are here. Of course, the basis, to my mind, of your Lordship's thoughts really would be that we should continue to be true to, the fidelity of the law, to integrity. And that, it is very easy to forget one's background and one's roots and one's oath to the rule of law. Because I once read a book who said you can't be talking about democracy when you have nothing on your plate. So if you're hungry, then perhaps your understanding of democracy would be, like stomach infrastructure. So in the midst of uncertainty and poverty, what I hear your Lordship saying is that we should continue to be steadfast. We should continue to have integrity. We should, whilst, during the uncertain time, we should continue, we should never forget continuous legal education, embrace technology, and continue to grow our capacity to combat, all of the issues that the uncertainties will throw up. I would round this off by saying that perhaps the biggest lesson, my Lord, here is that in spite of the uncertainty, lawyers should never sacrifice integrity, truth, and competence at the altar of stomach infrastructure. My Lord, thank you very much for your thoughts. We are extremely grateful. Extremely grateful. Extremely grateful. Finally, or perhaps for the penultimate time, my Lord, the Honorable Justice Daketima Gabriel Q, PhD, I'd like to emphasize. It will be good at this point, my Lord, to perhaps use the next 5 minutes to hear your thoughts on what you think regarding the thief. Perhaps your Lordship can put a very sweet icing on the cake. 5 minutes, my Lord. Thank you so much, man.
Thank you. My Lord, the keynote speaker, my Lord, the Chief Judge of Bar Association State, I acknowledge, my Lord, the President of the Customary Court of Appeal. Allow me to lean on the established protocols. I acknowledge members of the panelists. I have noted here that it's a difficult task for me to speak after one of the greatest Nigerian judge and jurist of eminent standing and scholarship has delivered a keynote address. It is even more difficult speaking after my Lord Afen Peter Jesse and Sonki J have spoken. You can see why I am the last boy standing here. Now, my difficulty stems from the fact that my Lord, the Honorable Justice Obande Festus Ogbunyi of Nigeria stands tall as one of the finest and most refined jurists whose intellectual fecundity and sagacity remains profound and very pronounced. My Lord, allow me to confess. Recently, I delivered 2 judgments. First, the one was delivered on the 26th day of March 2024 in the case involving Sir Celestine Omeya and the governor of Rivers State and 3 others. And the other one has to do with local government extension tenure. They have finished their tenure, they say they don't want to go. And the matter was assigned to me. Heavily in one of your book titled Guidelines to Interpretation of Nigerian Statutes, which my Lord the keynote speaker authored and published in Enugu by Snap Publishers 2019. That book of my Lord the keynote speaker guided me in the interpretation of the Rivers State former governor and deputy governor's pensions and fringe benefits law number 6 of 2012, as well as my interpretation of the Rivers State. Today I'm sitting very close to my Lord and I'm feeling very happy with myself. All what my Lord, the Honorable Justice of the Supreme Court have said, as my Lord Afen have rightly noted, I concur. As a matter of fact, I do not even have the competence, so to speak, or the jurisdiction to differ with what my Lord have demonstrated as the keynote speaker. Let me just say a few things and I will hand over the microphone. My Lord, the keynote speaker have already told us that the legal profession is a jealous profession that hosts only certified lawyers as its members. It is a vocation reserved for only those trained in the knowledge and nuances of the law. The legal profession remains the most coveted of all the professions in civilized society. I heard the Senator Kobri saying the best thing that can ever happen to a man is for him to be a lawyer. There is no other profession which puts the intellectual width of a person to test more than the legal profession. Consequently, in the time of socioeconomic uncertainty, the legal practitioner must realize that the profession is not instituted for making quick money. Now, I say so because since Saturday, February 20th, 1886, when Christopher Alexander Sapara Williams enrolled in Nigeria as the first lawyer at the Supreme Court, the legal profession has remained the conscience of the nation. Sapara Williams is the first Nigerian lawyer to be called to the English bar in 1879. It is good to have money in legal practice or in the practice of law. It is even good to have the things that money can buy. But it is good to check if you have not lost the things that money cannot buy. One of the things that money cannot buy is honor. And my Lord, the keynote speaker, have emphasized that. My Lord, Songi J have also emphasized that. The other is a clear conscience. The third is happiness. Money cannot buy inward peace either. Neither can it buy integrity or character. Therefore, do not allow your legal and professional fees, which you heavily charge your clients, to be the primary motivation for the work you do as lawyers in the time of socioeconomic uncertainties. When you regard the bar solely as a money-making enterprise, you have got it wrong. And you should not have joined the legal profession. Thank you so very much.
My Lord, that was extremely interesting. Please, I'd like to humbly crave your Lordship's leave to liken your remarks. You know when, and this is not with any prejudice to churchgoers here, please. You know when a preacher comes and talks about prosperity on Monday, On Wednesday, another one comes and talks about money. And then on Friday, W.F. Kumuyi comes and says, without holiness, you will go to hell. My Lord, that was extremely, whilst it is important to work very hard for money and for success and for prosperity, do not forget your character. Do not forget integrity. Do not forget, I'd like to think that we can pursue both of them at the same time. That was very, please, a round of applause. A round of applause. A round of applause. A round of applause. So at this point, I mean, the discussants have given us an extremely brilliant overview of what their thoughts are on the topic. We are a bit pressed for time. So at this point, we would like to take a maximum of 3 questions. Maximum of 3 questions directed at the keynote speaker. And I'm calling my Lord. Yeah. Directed at the keynote speaker. Sequel to which, if the other discussants and panelists have something to add in answering the questions, then we can take them and then we can round off. My Lord, it would seem that, my Lord, the Chief Judge, man, it would seem that I am constrained to hand over the microphone to you, man. And I can't do otherwise, man. My Lord, man. Somebody question or comment?
My Lord, Justice of the Supreme Court, you know, it's been interesting sitting here, listening to you this morning, and the panelists. First and foremost, I have an observation on specialization. Important that lawyers start to specialize. I want to, you know, like the other day I was talking to somebody and I was saying there's nobody that is specialized in divorce cases, and we have a lot of divorce matters now in Bayelsa, and I've made myself the divorce court. So I have been thinking, because you know some of the cases that come, divorce, the way the lawyers, the young lawyers, the way they handle it, some of them at the end of the day, they lose. Why? Because they are not specialized, they are not reading books, they have just gotten a brief. And so sometimes, you know, when you lose such a case, I don't think that they will recommend you to another person. So when you specialize in such a field like divorce, because we have a lot of divorce cases now in Bayelsa. A day I hear up to 3 or 4 divorce cases. In a week, sometimes up to 15. And even the issue of custody, the family court is here, there. Go and practice, so go and specialize. You know, in these times, these challenging times, a lot of areas we should specialize, especially in this our climate. It's not all about litigation. I remember when I was practicing, it got to a point when I was specialized more in corporate practice. And it paid off because I made a lot of money. So I think that specializing. And then my question, sir, is this. Can a lawyer who is a practicing lawyer be driving Bolt in the night? Bolt. Because it's happening and we are hearing it. So a practicing lawyer, can that person be a Bolt driver, use his Bolt, his car in the evening to be doing Bolt? That's my question, sir. Yes.
Okay, there's Mr. Bassi and that's the last time. My Lord, this thing you said, we've had, I and Justice Ekadi, we had a practical experience. We were in Abuja in December, and we ordered for Bolt, and we now saw MBA. We now began to engage the driver, found out that he's a lawyer, but not of Yenagoa, because Yenagoa lawyers do not do it. My lord, I can vouch for my members. Maybe they came from outside. Mr.
Thank you so much, Mr. Chairman. My name is Bright Abasi. I think I want to pick up from where my Lord, the Honorable the Chief Judge of Bar Association State took up from, talking about a lawyer engaging in bolt. Because when we talk about economic uncertainties, I think those are the kind of things that we should really look at. What are the other things that lawyers can do apart from practicing law that is not illegal or that is not, or that's allowed by the rules? You know, those are the things that I think we should really be talking about. Yes, a lawyer needs to have integrity. A lawyer needs to uphold the rule of law. But there are certain things that, for instance, okay, for a civil servant now, you are told that the only other job you can do is to farm. So no matter how hard things are for you, you just manage with your meager salary and then you look for a farm when you don't even have a land. So the law tightens you to a corner and you don't know what to do. Now, again, the keynote speaker talked about improving, talked about ADR and ODR, engaging in alternative dispute resolution. Now, I think of that as, when I think of that, I would say to myself, every lawyer aspires to be, a practicing lawyer aspires to be two things. You either want to go to the bench or you want to become an SAN, the peak of your profession. Or maybe as a civil servant, you want to be a permanent secretary and all that. But you discover that the criteria, for instance, for being either of these, either you want to be a judge or you want to go to the bench or you want to be a senior advocate. One of the things is that you must have judgments. And if you engage in ADR, will your ADR outcomes be accepted as judgments that you've conducted? Will ADR take you to the Supreme Court so that you can now say I have cases in the Supreme Court or the Court of Appeal wherein I can present to stand in for, and you've just, sorry, I had one more thing to say, but I think he has, yes. Okay, for time's sake, let me just leave it at that. Thank you.
My name is Zontare Timilaim. My Lord, the rule of law that the speech emphasized on, no doubt, is important just the way we head to every society. So my question is this, my Lord, that if the rule of law is really important and the judiciary believes in the rule of law, what has been done or what plan is put in place that those who disobey court orders, especially the political class, display negative examples for the citizens to follow? Because the complaint we are having about this economic crisis and the likes is based on the fact that people no longer follow court orders. What's the judiciary doing to curb this problem?
My lords, we received 3 responses. My Lord, His Lordship, the Chief Judge, made remarks. My Lord. Yes, let's deal with these ones first. Yes, my Lord, the Chief Judge, made very special comments regarding specialization. However, my Lord His Lordship went on to ask a very special, important question, which is that, can a lawyer practice law in the daytime? And that's how I like to put it. And at night, ride boats at night. That's the first. My Lord, Mr. Bright Abasi made observations about law being somewhat restrictive, and legal practitioners perhaps who have been told that they can only practice law or farm, but do not have the financial wherewithal to actually farm. He made that as an observation. And then went on to ask, what is the force of ADR? Does ADR have, for instance, the force of judgment? Does ADR have the sort of bindingness that a court judgment will have? That's for your Lordship's consideration. Finally, my Lord, Izontari Timilaimi asks, if the rule of law is that important and special, what are the courts doing to perhaps punish those who disobey court orders? My Lord, I'd like to yield the floor to your Lordship. Yes, my Lord.
Thank you very much for the questions. One must confess that the questions are very important, because it means that the paper has generated a lot of controversies, which is the aim of the paper. My Lord, the CJ has just asked, can a lawyer? Well, I won't go into the other niceties about divorce. I wouldn't know. The causes could be so many. But I know that the world is changing. And one of them really, which I have to share just in a minute, is you find out that a lot of things are happening today. Perhaps it could be caused by one of those things. You won't believe it, my Lord, that even some people from the law school, or rather, let me use the example I witnessed in Lagos. I went for a wedding, and we're in a hall that is just maybe half of this. And about 30 persons were in the hall, including myself. But I looked at the 30 persons. Do you know what each and every one of us were doing? Pressing phone. Pressing phone, so much so that you can come and pick anybody, nobody will even know. They were so engrossed in it that you will pick a neighbor there. You will not, in fact, if anything happens, nobody will escape it. So things have changed. I don't know, maybe such things may even be affecting the marriages, and then the divorce are becoming so many. But that's not the point. Can a lawyer who is a practicing lawyer drive boat? He does his practice in the daytime. In the night, he becomes a nocturnal driver. Well, I think the most important thing here, as a lawyer, because each and every one of us, I know the day each and every one of us here became a lawyer, he was quite so happy. You recall with nostalgia the day you were called to the bar to become a lawyer. But a lawyer must have an honor. A lawyer must have prestige. Sometimes even as a lawyer and even as a judge, you may not even have money in your pocket, but you carry yourself as if you are so rich. That's the only way you can survive. You see some of you carry yourself. And that's why when we talk of dressing, you dress very well. I mean, when you dress very well, nobody will even know that you don't have money. You must have an honor. And that's why we're taught in the professional ethics, the do's and don'ts of a lawyer. And so lawyers have to look into whether driving boat in the night or any of those such odd things come within the exceptions. Otherwise, if it's not, then it's true you are trying to make ends meet. But if somebody sees you as a lawyer, will he have regard for you? Will he come to brief you tomorrow? I very much doubt, because he tells me that he's not the one, maybe the one I saw the other day where carry somebody for this thing. So it's something that looks, I wouldn't recommend it at all. I wouldn't recommend it. We have to carry ourselves, even when you don't have money. But I love the profession. Even in my next world, I said I will become a lawyer. This is only a profession you dress up in the morning without money in your pocket. And while coming back, you have money. It's not so in other aspects of life. So people must carry themselves with dignity, integrity. You husband it. The legal profession, the training you have gone to before becoming a lawyer is a very serious one. And so I recommend that we have to do this with, must have the courage of a lawyer wherever one finds you. That is my answer to the question. Then secondly, the other one is, can ADR be judgment for sonship or for judgeship? Well, I'm not. I wouldn't say whether it is because I'm not aspiring to be a son anyway. At the time I became a judge, I'm not sure they were using that. But what we're talking about the paper is how do you come out? How will a lawyer come out of the economic, socio-economic doldrums, uncertainty that is in the country? How do you come out of it? Because I know in those days, when we were in practice, you charge a fee for maybe then, you charge a fee for 500,000, and somebody will say it's big money. But by the time you do the case for about 3, 4, 5 years, I mean, there may be no gain there, because if you check the number of hours you have spent, if you check the wear and tear in your cars, if you check a lot of other things. But if the matter is settled and you are paid very well, I mean, you'll be smiling to the bank, because the important thing is that you are comfortable and have the courage of a lawyer. So maybe it may be, because I think the ADR at the end of it, in some places, it is reduced as judgment of the court. And if it's reduced as, why can't it be used? Why can't it be used? But the principal thing we're talking about is one must find a way of getting out of this economic crunch so that you maintain your integrity and dignity as a lawyer. Thank you very much. The third question, I will assign it to my Lord, because I am now presiding. I will assign it to my Lord Afen to answer.
My Lord, I thank you very much. He has always been avuncular, and I've enjoyed these privileges in and out of court. My Lord, I thank you. Just to add to the ADR question, before I take this one. If you do one ADR, and I did a few as a practitioner, you will not bother whether they make you an SAN or judge. If you know what ADR actually entails. Believe me, one ADR, in fact, a retired High Court judge, I think that was Dr. Olakunle Orojo, told me that he did one, and all the salaries he was paid throughout the time he was a teacher, because he was one-time DG of the law school, and he became judge and retired. He said one ADR paid for all of them. So I beg you, do ADR. And ADR is not antithetical to your becoming a senior advocate of Nigeria. In fact, you need the money you will get from that ADR for those pro bono criminal cases. You will have to go and do in Yola for you to qualify. So please, let's not send this message at all. Doing ADR is not incompatible with your progression in the profession in any way. I need you to please look at that. The rule of law question from our brother, he is on Tari Timinlaye. Yeah. Now, you talk about what is the court doing to enforce its orders for those who are disobeying the law or the orders of the court. The first thing you would realize, which you must take home, is that the judicial role is not self-activating. Somebody has to activate you. So I throw it back to you. If you are a lawyer in a case in which there is egregious violation of a court order, what do you do? Have you brought an application? Followed the rules of the game? Of course, if you are taking out contempt proceedings, it must be personally served, and do all of the prerequisites for the enforcement of your order. And then the courts do not do what they are supposed to do? I do not think so. So the ball again is at your court. You know that somebody has disobeyed a court order in your favor, and you do nothing about it, and you are expecting that the courts will jump into the fray and punish that person for you. It will not happen. Secondly, we do not have an enforcement machinery. The courts, we don't have the sheriffs. In America, the sheriffs are even more feared than the regular police. Maybe we should maintain a sheriff's department with full powers to enforce our judgments. Maybe, and only then will you be able to place that burden or that blame on the doorsteps of the lawyer or of the judges and the courts. Thank you very much.
Okay, so their lordships have granted an order for extension of time. I've not even landed. Some people are raising their hands already. For 2 more questions, just 2 more questions. A maximum of 2. 1 minute, please. A maximum of 2. Can somebody help me with it? One person, 1 question. Thank you. Okay, please come. Come, please. Mr. Oposugi, hurry up. Just 1 question, please, because I know you like bullet points.
Please permit me to stand on the existing protocol. I have just this 1 question. The quotation from the GCA is that it is not about the powerful, but it's about the species that is able to adapt. But I have come to observe that in our legal profession, there is this slowness in adaptability. And that is why I want to ask. What? There is slowness in adaptability, and that is what is definitely affecting the profession in terms of earning. And my question is on delayed justice. I can see that for political cases, there is this culture of expedite decisions. A case by law, a political case, not more than 180 days, but another important case will take like 10 years. I have a case I find in the Court of Appeal that is already 10 years, but we have not moved a motion. Now, confidence is eroding. My question is, why can't the justice system itself evolve to meet the population challenges? We still have just 1 Supreme Court. And how many panels, how many judges in the Supreme Court for the population that bring matters? Also, the Court of Appeal is decentralized, but how many matters? Oh, I have asked more than 1.
My lords, I said it as he was coming. Okay, any other? Sorry, let me take him. Sorry, raise him first. Okay, sorry, I'm sorry. Let me take it. Great. I'm sorry, I'm terribly sorry. Last question, please. Please keep it brief and simple. Thank you. Just 1 question.
Okay. Thank you for the opportunity. I am Temedie Peter Great. My lords, a great privilege to borrow the words of the Chief Judge to meet my Lord, our keynote speaker, flesh and blood today. I'm indeed grateful. My question is an aspect of the topic I would like the panelists to please interrogate. That is with respect to uncertainty in judicial outcomes. My lords, is a great concern to lawyers as well as litigants that judicial outcomes these days are quite uncertain. And I want to know what's the cause for it. Now, I agree there are situations where there could be genuine slip on the part of the bench, but where in cases that are very clear with clear precedents, the outcome becomes uncertain, as the Supreme Court emphasized in the Plateau State Election Tribunal that came before the court. The Supreme Court got it very hot on the court, and I'm concerned. A client of mine actually asked me out of worry. He said, what happens when all this, you go for justice and then you get something else? What happens? Is there any consequence, or everything goes with impunity? So I want to know what's the cause of this uncertainty in judicial outcome and how can it be corrected? Thank you.
Outside the conference. Okay. The first question, delay in justice. That's after speaking about the adaptation, slowness to adaptability. He talked about delay in justice. And the delay, well, and let me just take the two of them together anyway. And uncertainty as to outcome of judicial decisions. Or rather, well, the delay we are talking about, I don't want to pass the buck, but since we are talking about lawyers for today, uncertainty of legal practice, uncertainty in legal practice, and that's what we are talking about today. The delay we should be talking about now, it should be how are lawyers diligent in the preparation of the cases. And you find out that you go to some courts, you'll be confronted with a lot of applications. Hardly can you file those in the appellate court, my lord will bear witness. You see a file that is clean. The notice of appeal is filed, the brief is filed, the record is transmitted, the two briefs are filed, you go and hear it. You are confronted with a lot of applications from lawyers. That's the truth. One has had the opportunity of sitting, you have about 10 applications in a matter. You're asking for application to amend this, application for extension of time, this one, and this is what I mean, because we have said we are talking about lawyers. And it may not even, if you look at it that way, aspect, not judicial delay now, because that's not what we are talking of today. And lawyers should be diligent. Diligence is very important. Do your matter and do it quickly. Get whatever you're supposed to get from it, and then get out of the socio-economic crunch. And then the other one is on uncertainty as to outcome of judicial decisions. Gentlemen, or my friend who asked a question, what were judicial uncertainty or political? Then will you please answer that question? So we won't go outside the perimeter of what we are doing today. Thank you very much, gentlemen.
Thank you. My lords, thank you very, very much. You would agree that the panel has done very good justice to the theme and to the discussions. My lords, the Honorable Justice Ogbunya, JSC, CON, we want to say a very big thank you for your time. We're extremely, extremely grateful. My Lord, Honorable Justice Peter Afen, JCA, we're extremely grateful for your time. Thank you so much for coming and for gracing this panel with your presence and your erudition. My Lord, the Honorable Justice Timipres Songi, thank you very much for your time. Thank you for coming. Thank you for giving us that paper and that talk. We're extremely grateful. My Lord, the Honorable Justice Daketi Makio, PhD, thank you very much for your time. We're extremely grateful. It was an extremely interesting, exciting grateful for your time. Thank you. So a round of applause for the panel, please. And now take you back to your seats. Sorry, sir. Just very quickly. Let us take pictures. Just very quickly. Where's the photo? Please,